So what are the parts of a patent licensing agreement? Hi everybody, I'm JD Hoovener, owner, founder, and patent attorney at Bold Patents Law Firm, also the author of Bold Ideas, the Inventor's Guide to Patents. That book and a great resource for you is right below. Please click the link. It's our Bold Inventors Kit. Learn about the whole process, what patents are all about, and some of our greatest resources on patent application drafting, patent searching, and our patent monetization success. So this question is great. What actually is in a patent licensing agreement? How do you work through that and use an attorney to help you navigate through the process to get the best deal possible? Well, I've got 10 parts. I'm going to cruise through this today with you, making sure you understand each piece and how you can make the most of it. The first part of the licensing agreement is, of course, the grant. That is the most important part. That's when a patent owner is giving up, if there is one patent or a portfolio, they're giving up their rights, the ability for them to make, use, and sell or import their invention. They're given that ability to exclude that to someone else or some other business, whether that's an exclusive license, non-exclusive, or a sole license. The attorney's role is to help that applicant, either you represent the inventor, make sure they're giving the right amount of rights away, and making sure that each of those pieces of the puzzle are negotiated well. If you're only going to deal with a manufacturer, of course, you're only going to allow the ability for them to sell it. You're only going to be negotiating the ability for them to manufacture it, not sell it. That's a simple example. Exclusive is when you are giving up the ability to have them be the only one to manufacture your invention. You're not going to be talking to several manufacturers. It's an exclusive licensing agreement where additional benefits come into play. Second is the term and the extension. The term and termination. So what it covers is how long of a period of time. How long is this license good for? Is it the life of the patent? Or maybe it's a lesser time, 3 to 5 years, to sort of test the waters to see if all parties are going to benefit from this transaction, and allowing a termination that happens earlier before the term of the patent expires. This is negotiable, and this is the attorney's role to really make sure that there's enough flexibility, that if the inventor has some wild success, they can be able to come back to the negotiating table and ask for more money. So the third piece is about the money itself, royalties and payment structure. This aspect of the patent licensing agreement is talking about how there's either lump sums or running royalties, milestone payments, or profit sharing that occurs at each step of the way. So each of those different methods has ways to fail. And so in the contract, your attorney will need to negotiate ways to make sure there's no issues about breach. How will this contract be broken? Could someone break it lawfully? Or maybe this agreement now runs afoul of, let's say, antitrust laws, or there's fair competition. How is there going to be a definitive way to determine how much money is owed at each time, at each milestone, at each whatever is agreed upon, and the enforcement mechanism for that. Beyond that, there's section 4, which is the scope of rights and limitations. This is going to cover things like sub-licensees, modified derivative works. As you're creating the project, can you hire someone else? Can a subcontractor perform under this contract? Specifics regarding derivative works, which is a fancy term for similar products. So if you're having a company that's able to make and use your invention and sell it for you and give you a royalty, are they able to develop other products, even competing products that might actually diminish the market value of your own product? The fifth section is confidentiality and trade secrets. As you're developing a product, no doubt, versions 2, versions 3 are going to be developed. And how does that information stay protected? Who has the authority to deliver, receive, and store data? And how is that information, which is valuable, that is what a trade secret is, how does that exchange and kept secret within both the licensee and licensor? 6 is quality control. As products get developed, made, and sold, they need to have quality checks throughout the process. Who is doing that quality check work? How testing requirements are established, and if there's regulatory bodies, how are they going to be able to navigate through that and meet each of those thresholds as they get forward and move toward royalty payment? Section 7 is infringement and indemnification. So remember that exclusive licensing agreement typically those that have exclusive rights also are in the same shoes as the inventor, as the owner of the patent. They will need to join forces or even on their own pursue infringers because they have been obligated to do so. In the indemnification clause, as you've probably seen it before, it's where there's no unnecessary liability brought toward the party that's licensing. The attorney will make sure that it's going to protect the client in that case. Section 8 is dispute resolution. This is going to cover standard type contract law material where there's a specific place where mediation could occur, arbitration, to avoid costly suits in federal or civil court. So it negotiates fair resolution without having to pay a lot of attorney's fees. So governing law and jurisdiction is Section 9. Section 10 is the improvements in ownership of future innovations. This is really a forward-looking clause. It talks about who gets to make improvements and who will have the rights and what the terms are, or whether you come back to the table to negotiate each subsequent invention or innovation that happens on the shoulders of these current technology components. Because years will go by and version 2, version 3 will come up. Who owns those and what are the deal terms around each of those? So a patent attorney will help you think about the invention and how it matures over time and how you can implement all of those aspects into this contract over these 10 sections. So I hope this is educational for you. If you have more questions about what happens in a patent licensing agreement, feel free to put those comments below. Don't forget to grab below the Bold Inventors Kit to get started in your journey today to get started on patenting. I look forward to helping you. I'm JD Hoovener, owner and founder here at Bold Patents Law Firm. Have an awesome day, everybody. Go big, go bold.